Supreme Court added case to February 3, 2026 docket that could determine whether concealed carry permits mean anything. Hawaii-originated Wolford versus Lopez forces court to resolve fundamental tension between Second Amendment right to bear arms versus property owners' right to control their property. By the end of this video, you will know all the implications, so let's get into it. While 2022 Bruen decision established right to carry handgun outside home for self-defense and struck down special need requirements, it left critical question unanswered. Can private businesses prohibit firearms on their property with force of criminal law? Can shopping malls ban guns? Can restaurants post "no guns allowed" signs backed by criminal penalties? February 3rd, oral arguments will determine whether concealed carry permits grant access to private property or whether property rights trump Second Amendment. Subscribe because Wolford versus Lopez represents biggest Second Amendment case since Bruen and court's resolution of this property rights conflict determines whether your carry permit works in real world or becomes useless when businesses prohibit firearms. After Bruen June 2022, states struggled to define sensitive places where firearms can be prohibited. Bruen said courthouses, polling locations clearly qualify. But what about shopping malls, movie theaters, restaurants, office buildings, apartment complexes? States took different approaches. New York passed laws saying default is no guns on any private property unless owner explicitly permits. Texas said property owners can prohibit with signage, but violation is trespass, not criminal offense. Hawaii made carrying on private property with no guns signage a Class C felony. This created patchwork of conflicting laws. Wolford versus Lopez emerges from Hawaii and forces court to resolve whether property rights or Second Amendment prevail. Let me break down what Bruen established and left unclear, what Wolford case involves, how different states handled private property question, legal arguments both sides making, and what Supreme Court decision could mean for where you can actually carry. Number 1. What Bruen established and left unclear. Bruen core holding, NY State Rifle and Pistol versus Bruen, June 23, 2022, held Second Amendment protects right to carry handgun outside home for self-defense. Struck down New York's proper cause requirement demanding special need. Justice Thomas established new test. Gun regulations must be consistent with nation's historical tradition of firearm regulation from founding era. What Bruen allowed. Government can prohibit firearms in sensitive places like schools, government buildings, courthouses, polling places. These have historical pedigree as places where firearms traditionally restricted. What Bruen left unclear. Did not define outer boundaries of sensitive places. Can private businesses open to public be treated as sensitive? Mentioned historical tradition included ability to exclude armed individuals from private property, but did not clarify whether this allows modern states to criminalize carrying on private property that prohibits firearms, whether property owners' rights override carriers' Second Amendment rights. Number 2, Wolford versus Lopez case facts. Case background: James Wolford, Hawaii resident with valid concealed carry permit, was carrying concealed handgun at Ala Moana Center shopping mall in Honolulu. Mall has no firearms policy posted at entrances. Security observed Wolford's firearm, printing, called police. Wolford arrested under Hawaii statute making it Class C felony to carry firearm on private property posted with no firearms signage. Wolford's argument: Hawaii statute violates Second Amendment by allowing private property owners to criminalize constitutional right. Shopping mall is public accommodation open to general public, not genuinely private space. If property owners can ban firearms with criminal law, concealed carry permits become meaningless because most businesses prohibit guns. Creates public spaces, privately owned but open to public, where Second Amendment doesn't apply. Hawaii's argument: property rights are fundamental, predating Constitution. Common law recognized property owners' right to exclude armed individuals. Hawaii statute codifies traditional property right. First Amendment doesn't grant right to speak on private property against owners' wishes. Second Amendment doesn't grant right to carry guns on private property against owners' wishes. Hawaii law is content neutral. Legal questions. 1. Does Second Amendment right to carry extend to privately owned property, open to public over owner's objection? 2. Can states criminalize carrying on private property that prohibits weapons, or is it civil trespass? 3. What is scope of sensitive places? Can private businesses be sensitive based on owner's preference? 4. Does historical tradition support criminal penalties for carrying on private property against owner's wishes? Number 3. How states handled private property after Bruen. New York/California/Hawaii approach. Default rule: firearms prohibited on all private property unless owner posts signage affirmatively permitting. Violation is criminal offense. Opt-in framework means effectively all businesses prohibit guns. Gun-free zones blanket state despite Bruen. Texas/Florida approach. Property owners can prohibit carry with specific statutory signage. If proper signage posted and carrier refuses to leave when asked, violation is criminal trespass, not weapons offense. Florida allows property owner to ask armed individual to leave. Refusal is trespass, but simply carrying without being asked to leave is not criminal. Constitutional carry states. Among 29 constitutional carry states, some allow property owners broad authority with criminal penalties. Louisiana. Others treat violation as trespass only. Tennessee. Still others provide no statutory framework, leaving common law trespass as only remedy. Vermont. Number 4. Legal arguments, both sides making. Property rights side. Property ownership includes right to exclude, fundamental to common law for centuries. Blackstone described right to exclude as among most essential property rights. Supreme Court in Loretto versus Teleprompter recognized right to exclude is one of most treasured strands in owner's bundle of rights. First Amendment doesn't grant right to distribute pamphlets on private property against owner's wishes. Lloyd Corporation versus Tanner. Second Amendment should work same way. Property owner has legitimate interest in controlling dangerous items on property. Historical tradition supports property owners excluding armed individuals. Second Amendment side. Constitutional right cannot be nullified by private action. If property owners can criminalize carrying, Second Amendment becomes meaningless because virtually all space is private property. Shopping malls, restaurants, grocery stores, office buildings, all private. If all can ban guns with criminal penalties, right to bear arms exists only on public sidewalks and in home. This renders Bruen empty. Constitutional rights don't vanish on private property. Police cannot search without warrant in shopping mall. Property owners' preference cannot override constitutional rights. Historical tradition shows public accommodations, inns, taverns, markets, treated as quasi-public spaces. Modern shopping malls are functional equivalent of town squares. Allowing private ban creates perverse incentive, where anti-gun owners effectively legislate gun control through property rules. Number 5. What decision could mean? If Hawaii wins, property owners empowered to prohibit firearms with criminal law. Wave of no-guns policies at malls, restaurants, theaters, stores. Businesses prohibit to avoid liability. Result: most places become gun-free zones despite Bruen. Concealed carry permits largely useless outside home and car. Carriers face criminal prosecution, not just trespass. If Wolford wins, property owners lose ability to prohibit with criminal penalties. Can still ask armed individuals to leave, refusal remains trespass. But simply carrying on property with no guns policy cannot be criminalized. Result: concealed carry becomes practical in most locations. Gun-free zone signs become requests rather than criminal prohibitions. Property owners' remedies limited to civil trespass. Likely compromise. Court could rule genuinely private spaces, residences, private clubs, can prohibit with criminal penalties, but public accommodations, malls, restaurants, theaters, cannot criminalize mere carrying, only refusal to leave when asked. This balances property rights in truly private spaces against Second Amendment in quasi-public commercial spaces. Would adopt Texas/Florida approach where violation is trespass unless carrier refuses to depart. What gun owners should do. Understand your state's current law on private property and firearms. Research businesses' policies before entering. If confronted, comply immediately by leaving to avoid trespass charges. Support Second Amendment organizations filing amicus briefs. Contact state legislators to push for trespass-only laws. If your business owner, understand no gun signs may create liability if customer injured in shooting is disarmed. Monitor case, oral arguments February 3rd, decision likely June 2026. Bottom line, Wolford versus Lopez forces Supreme Court to resolve property rights versus Second Amendment. Background, Bruen, June 2022. Established right to carry handgun outside home for self-defense. Struck down special need requirements. Allowed restrictions in sensitive places like courthouses, polling locations, but left unclear whether private property can be deemed sensitive, whether property owners can criminalize carrying against their wishes. Case facts. James Wolford carrying concealed in Ala Moana Center shopping mall in Honolulu with valid permit. Mall posted no firearm signs. Arrested under Hawaii law, making it Class C felony to carry on private property with no guns signage. Wolford argues law violates Second Amendment by allowing businesses to nullify constitutional rights. Hawaii argues property rights are fundamental, predating Constitution, and owners have right to exclude armed individuals. Legal questions. Does Second Amendment extend to privately owned property open to public? Can states criminalize carrying on private property that prohibits weapons? What scope of sensitive places exception? Does historical tradition support criminal penalties for carrying on private property? State approaches, New York/California/Hawaii, opt-in. Guns prohibited unless explicitly permitted, criminal penalties. Texas/Florida, opt-out. Property owners can prohibit with signage, violation is trespass not criminal. Constitutional carry states vary widely. Arguments. Property rights side says exclusion is fundamental property right. First Amendment doesn't apply on private property, so Second Amendment shouldn't either. Historical tradition supports exclusion. Second Amendment side says constitutional rights don't vanish on private property. Modern commercial spaces serve public function. Allowing private ban renders Bruen meaningless. Potential outcomes. Court rules for property rights equals most of America becomes gun-free zones. Permits useless. Court rules for Second Amendment equals property owners lose criminal enforcement, must rely on trespass. Compromise equals genuinely private spaces can prohibit, public accommodations cannot criminalize. Gun owners, know your state law. Research business policies, comply if confronted. Support amicus briefs. Contact legislators. Monitor case. Prepare for changes based on June 2026 decision. Subscribe because Wolford versus Lopez decision determines whether concealed carry permits work in real world or become meaningless when private businesses prohibit firearms. February 3rd, oral arguments will decide whether Second Amendment exists in private spaces or only on public sidewalks.